So part two of our series on real estate contracts is we're going to be talking about deposits, land title certificates, representations and warranties, closing conditions, and closing process. So let's get started. So deposits, when we talk about deposits, deposits are the amount of money that you're placing in advance on a contract to which is going to be tied from the buyer's perspective to them actually fulfilling the overall contract. And the risk to the buyer, if they're not able to fulfill the contract, is that they can lose that deposit. And so that amount specifically can vary quite a bit. And you'll see in like 4.2 and 4.3. You can name someone else for holding it. It doesn't necessarily have to be a lawyer or something like that. And you'll see that in private contracts more often, especially within agricultural contracts, you'll see that much more. But in looking at the overall buy it, again, 4.3, the buyer will pay a deposit of this amount, which will form part of the purchase price. There might be multiple deposits. Frequently within residential purchase contracts, there's not. But sometimes where there might be is if there's a substantial length of time that someone's holding it. So it might be 5,000 1 month, and then because closing isn't until 6 months down the road, they might say, okay, but you have to put a much larger deposit 3 months from now, just to ensure that they're actually going to be fulfilling it. So when I have a larger closing time distance, sometimes you'll see two deposits with a much larger second deposit just to confirm that they're okay. And then the buyer's risk is obviously that they lose their first deposit if they aren't able to fill, plus any other sort of steps that the seller may have. As says again, if the buyer fails to pay a deposit at the agreed upon date, the seller may void the contract at the seller's option and give the buyer written notice. Then again, the seller's option expires when the seller accepts the deposit, even if it's late. And the funds get deposited into a trust account, and interest on the deposit is not paid to the seller or buyer. Again, typically as a lawyer, those funds get paid to the law foundation, which goes to fund things like legal aid and community legal clinics and other sort of pro bono initiatives. So overall, socially beneficial. And again, so then that deposit forms a part of the contract. And if everything is accepted, then that forms part of the purchase price. If the contract is accepted, but there's a condition on the contract, and we'll get down to that down below. But obviously the most common one tends to be things like inspections or financing. And after that condition is not waived because either financing didn't go through or a failed inspection, then the buyer gets that deposit back because they haven't waived that condition. So frequently what happens, and some people might miss this when they're looking at a statement of adjustments, is the deposit gets paid through the real estate brokerage. And then the real estate brokerage then, for the seller who pays commission on the sale, will then deduct their commission using that deposit. So say the commission was $10,000 and the deposit was $5,000. They'll send a letter to the seller's lawyer saying, you owe us $5,000, the difference. And so sometimes people can get confused when they look at the adjustments and they look at the commission amount. And they missed that one fact, and that's included in 4.8C there. So then land title. So title of the property is free and clear of all encumbrances, liens, and interests, except for those implied by law, non-financial obligations, homeowner association caveats, items a buyer agrees to. So we're going to do a different video, and we're going to look at a couple different land titles to kind of go through some of those more specific interests that can be registered against land. But for the most part, what this means is that when you buy a property, the mortgages or any caveats or any writs, things that's associated with, I've put something on this property because the person who owns this property owes me money, get discharged through the sale. So when you say free and clear of all encumbrances and liens, that's what it means. CRA is another common one. So someone owes taxes. So sometimes the government will file a lien against the property for taxes. Builders liens are another one. So they've done improvements to the property and they haven't paid everyone. So they may file a builder's lien. When I say writs, someone has a debt and they've lost a judgment against them. And so again, they might register a writ against the property to collect on that judgment whenever that property is sold. So typically all those things get paid out. So then what's left? So frequently on a land title, again, you'll get things like utility right of way, allowing the utility companies to access your property to deal with things like water lines or electrical lines, or SHAW, to be able to access a SHAW box that's on the property for, a larger space. So those are all common ones. Even more broader ones, things like easements to allow someone to access, a certain section of your property. You'll see those more within rural residential areas, and then again, when you talk about, outside of urban areas, you'll have things like some type of covenants or easements for like an oil well company to access an oil well that they're paying for on a property. Another common one, it says, is homeowner association or condominium association covenants. And there'll be conditions sometimes on the property that says, as a condition of owning this property, you agree to do these things. So that's when you see like townhouses that all have the same outside look and appearance to them. Typically, there's a restrictive covenant on it that says you can use this type of material and these types of colors to paint and decorate the external part of the properties. But again, we have another video. I encourage you to watch our land house video when we kind of talk about what a land house certificate looks like. So reputations and warranties are essentially the promises that both the seller and the buyer are giving to each other. So when we talk about those promises, these tend to actually be more straightforward than they might appear when you just read them. So the seller has real rights to property. What that means is that the seller can actually sell the property. They don't have some other condition on them, like a trust or some other restriction that would prevent them from selling it. Seems like a fairly safe promise. Same thing. The seller is not a non-resident for purposes of the Income Tax Act. What that relates to is if someone spends more than a certain amount of time outside of Canada, they can have to pay a withholding tax to ensure that any capital gains or other county taxi stuff gets paid accordingly. And so as a lawyer there or a realtor, whoever's doing the transaction, they would just want to know that in advance. And so you're making a promise that you're not. And again, similarly, no one else has any right to any of the goods that are listed above them. We talked about attached and unattached goods. No one has a lien against that. There's no leases or other corresponding documents or contracts that might affect the ability to sell those types of goods that are included with the actual land itself. Deed can actually be really interesting. And sometimes you'll see that where people are operating a business through their shop that they've attached to their acreage. And technically, they've never actually applied for either the zoning or the permitting to do so. And so, but when someone goes there and buys it, sees what they're doing, they're like, oh yeah, I'm going to do the same thing. And they might run into issues with that. And so again, that's why that condition's in there as well. And again, locations of the buildings and land improvements are essentially compliant with municipalities. So we talked about like real property reports and title insurance. That's kind of one way that addresses it, that they've been improved in writing if there is any sort of encroachment on those. And when you do get a real property report, for example, with compliance, sometimes it'll say, well, it's not complying, but we're fine with it because we don't care that although it's 3 inches closer than it's allowed to be to the municipal sidewalk, we're not going to do anything about it. And the municipalities will do that quite often. But again, then it's just acknowledged and agreed to in writing by the municipality. And similarly, again, it might say it complies with any restrictive covenants, as I was mentioning just before. If there was, for example, a covenant that said this building had to look a certain way, or it had to be at a certain dimension or size restriction on it, you're just also saying that it's compliant with that. And that's again what a real property report would do. We talked previously about that material latent defects. And again, this is just saying that they've been disclosed in writing in this contract. So if you're aware of something, you're thinking again, before, as we talked about in part 1, is there a material latent defect that you should be disclosing? Talk to your realtor, tell the other person, put at the bottom of the contract, there's a section where you can write it in. And again, similarly, you have all the permits that you're required to in relation to the property or development of the property. Again, makes sense, as we talked about with real property reports as well. You've built a garage, but you never got a permit to build the garage. And so that garage adds value to the property that's being sold. And there's a potential there from the municipality of saying, look, unfortunately, you can't build this garage. You're going to have to take it down. You didn't get a permit for it. So then that decreases the value of the property. And that obviously causes issues then down the road if that happens. And again, the other thing too is to know that if those representations and warranties have changed between the start of the contract to the end of the contract, then they're obligated to provide that information. And so, for example, what happens occasionally sometimes is there's a debt that gets registered between the time of the purchase contract to the closing date, and they register writ against the property saying, hi, this person owns this property, owes me money. Well, then what you have to do is you have to adjust that to make sure that that writ gets paid out from the sale proceeds, even though that might not be in the contract. And it's up to the seller to make sure that the buyer is informed of those sort of changes that might happen. The Dower Act. Now, the Dower Act is a fairly unique thing to Alberta. A lot of jurisdictions have changed it over time. It's a very old piece of legislation that says that if you are married, so it doesn't apply to common law couples, and only one of those individuals is on title, then the other person has to sign off on the sale of that property so long as either spouse has lived in the property. That's kind of a generalized version of what it covers and why it's here. And so, as it says, the non-owner spouse has to sign the contract or sign an acknowledgement. Now, what happens when people separate when they're married is sometimes they'll just get the other person to sign something called a dower release, which can be registered against title. And that dower release basically says that I forgo my right to dower. And people do that as they go through a family law process. This is, again, most jurisdictions don't have this anymore. And so if it was someone new to Alberta, they might not realize this happens. Where it can really come into play is that if this is a property that was purchased while two people were married, and it's not whether they're separated or not, but while they're married, and either of them lives in that property, because they don't both have to live in that property, they require consent of the other spouse to sell. So where that leaves someone is that they could be separated for 10 years and then want to sell and still require the consent of the other party. And then obviously have to track them down or figure out where they are. And so, this is one of the reasons why in looking at your property, and whether, especially if people are separating, that they might want to get those sort of dower release, dower consents done in advance from the other party to ensure that they can actually deal with it themselves. The trick is if they do that and they still aren't divorced down the road, is then it would apply, even if they do get a dower release, it then applies to their next property, because then again, as I said, one of them has lived in that property. So when they want to, say, resell that one, that could be an issue. And they have to go through the same process over again. So conditions are the parts of a contract that we're saying, we agreed to this, but for these things. And these things just have to happen in order for the contract to occur. So the most common that we're looking for is financing and inspections. But there can be other buyer's conditions as well. So financing is obviously the most common. It is simply that if I'm able to obtain financing from the bank to afford the purchase price, that's how I can do it. And so if they can't obtain financing, then obviously they can't follow through. And so they would get their deposit back and it would be canceled. It's really important to know when they look at conditions, though, that the wording under 8.1a is read. So they must make reasonable efforts to fulfill them. So sometimes you'll have people who will buy it with no intent of actually fulfilling the financing, or they know that they're not going to get it, but they still put an offer in anyway, just to see if they could get a lower offer or a lower dollar amount. They can run into trouble because they could effectively say, well, you didn't take the reasonable steps if the other party finds out, that you knew in advance that you weren't able to do this. And so there could be costs associated with that from a litigation perspective. And so you see that once in a while, but again, it's something to be conscious about. There's really probably nothing practically that anyone can do about it, but that does happen once in a while. Property inspections. So a lot of times property inspections come out, and again, we'll have another video about home inspections and how to deal with those and some of the things they say or don't say, or some of the times they say words and they're really meaning something more serious because of the liability involved in doing property inspections. But the focus when you're looking at a property inspection is just saying, like, look, I want to have someone who is licensed, who knows about building homes, to look around and let me know if there's any big issues here. remember that the conditions on it are that you have to provide material defects that the other person wouldn't know from a reasonable inspection. So that's why you hire someone to do that inspection for you. The other big part of why you want to get a property inspection is just that as well. You want a third person who is not objective. Sometimes I've ran into issues where people are like, well, just like the color of the home and the size of the rooms, and I could just see, this is where I would live. And all of these subjective elements don't actually go to the objective element of, is there something wrong with the property that you should know about before you buy it? So the apartment store, again, will look in the attic, look in the basement, look along the window lines, see whether the windows are warping due to rain coming in. Look at the furnaces, look at the hot water tank, look at the deck and how it's the pilings on the deck are. Look at the fencing, see if the fencing's coming loose. Look at that all the electrical works, all the tap pressure, the water pressure throughout the house is fine. Like those are all things that a home inspector would look at, to give you an idea of, is there something there? And then frequently what can happen is when the home inspector comes in, does an inspection, says, hey, look, here's some things that are going to need to be improved. The oven isn't working. And what might happen then is that a second round of negotiations occurs to adjust for the fact that some of those things aren't working, or alternatively, conditions on the seller to fix certain things prior to closing, on the condition that if they don't fix them, then they'll reduce the price by a certain amount. So those are common things that come out of property inspections. But again, as I said, we're going to have another video. You can listen to that video, again, specifically discussing property inspections and what to look for. Then probably the third most common is people often sell their house and buy their house within a very short period of time. And so part of the condition of making a purchase might be that they also need to sell their property within a period of time as well. So they can't buy this new one if they don't have the money from the sale of the other property. So again, very common condition that you'll see. Additional buyer's conditions can be anything really. Additional documents, additional inspection documents. When you're looking at more acreage type properties, or, so kind of like just around an urban center, you'll see things like water testing. So if they have a well, make sure the well's tested. Same thing for sewage. If they have like a septic tank or a septic field, just to make sure that that's have that inspected, might be another type of condition. There might be conditions related to, I said, specific obvious defects that the buyer has received from the seller and has been disclosed to them, such as, hi, this window was broken. And so there could easily be initial buyer condition to be like, the buyer shall repair this window by this date. So those are all kind of common ones that you'll see there. Again, just kind of depends on the unique needs of individuals in the transaction and the unique situation of the property itself. So what happens after you sign a purchase agreement is that you then can waive those conditions. And if those conditions aren't waived, then the overall purchase agreement is voided unless that condition waiver then happens. So the condition isn't waived automatically. It has to be waived in writing between the parties. And the condition can be unilaterally waived by the party whose benefit the condition is. So for example, if it's a financing condition that's to the benefit of the person buying the property, then once it's waived, the seller can't void the contract. The seller's still stuck with the contract, even if something changes in their lives, or if they get another offer or something like that, they're still stuck with that contract. And again, they can attach different schedules or different things that, if there's a tenant in the property, then maybe that gets attached to it so that both parties are acknowledging that here's the lease and the tenant's going to be there for this period of time, even after sale. Sometimes in dealing with tenancies, is the payment of rent will transition a couple months before in order for the to kind of credit the buyer for a certain period of time. And so there's different things like that can happen.